We have
How
covered.
is your health, sir?
Hmm?
I wish to ask, how is your health now?
Better, much better. Taken rest. I had gone to my farmhouse and taken rest and came back. When I go outside and take some oxygen and come better. Yeah, I think we covered admission part. That is section 17 से लेकर 17, 18, 19,
23 tak.
23. These are all containing admissions.
Sir, we
Admission.
did till 23.
Yeah, 23. So that is all admission part. Admission has been defined in the Evidence Act. Admissions are applicable to both civil proceedings and criminal proceedings. Now, today's topic will be confessions which are commencing from section 24 onwards, 24 से लेकर 26 and 27 till 30 तक जाएंगे. Principally, the confessions. Confessions are normally the exculpatory statements where the accused person confesses to the crime. Of course, confession, like admission, confession is not defined in the act. Please note that here you have to see the definition elsewhere from other authors. Some authors have given the meaning of what is the meaning of a confession has been defined by some authors, not in the act. So basically, there are two types of confession: exculpatory statement or inculpatory statement. Is only exculpatory statements, confession, are admissible under the provisions are dealt with. Inculpatory means the accused says, I am innocent. So that is not dealing with innocent part. It is dealing with the part which says that here I have committed the crime. To what extent, whether the confession of the accused person is voluntary, non-voluntary, whether he's making under coercion, under duress, or under some instigation, or under some promise, that the court has to see. It's a very onerous job that will deal with it now. Open section 24, वहां से पढ़ लेंगे हम लोग, and we'll explain each section. Yes. Yeah, confession caused by inducement, threat, promise, when relevant in criminal proceeding. Underline the word, they are relevant only in criminal proceeding, nothing to do with the civil cases. A confession made by an accused. उससे पहले आपने आर्टिकल 20 के अंदर पढ़े थे, isn't it? Article 20 के अंदर an accused person cannot be compelled to make statements which go against him, criminate himself, isn't it? That is at the stage of the investigation. Now, this is the stage where the trial is taking place in the court of law, where it is produced before the court of law. So, Article 20, subclause 3 is a stage where is an interlocutory stage or initial stage where investigation take place either under section 161, 162, recording of a statement under CRPC. Now, this is a stage where the accused is arrested, on the allegation of having committed certain offenses, either cognizable or non-cognizable, that at the time of the recording of his statement by the police officer under 161, 162, he says that I am admitting the crime. Then the police officer himself cannot record the confession. It has to be done under the supervision of a judicial magistrate. That is how it is done. Okay. So a confession made by an accused person is irrelevant in a criminal proceeding if the making of the confession appears to the court to have been caused by any inducement. Does the police officer has promised you that he will give 1 lakh, 10 lakh, 5 lakh rupees if you admit the crime, or he will let you off? He will make your family very happy, financially solvent. For A reason, B inducement, some kind of promise is given to him. Then I will see to it that here you will not be convicted. And I will see to it that here lesser punishment is given just 1 or 2 days. And I will see to it that you are rewarded. This kind of inducement if given by the police officer while interrogating him and induces him to make a confession of the crime, that is not valid. The court will ascertain this. Court will find out this because the court ultimately, it is the confession, the judicial magistrate record of the parameters and safeguards are laid down in section 164 of the CRPC. You all know that. Okay. Has been caused by inducement, number one. Threat or promise, whether the police officer, investigation officer gave you any threats of dire consequences, that I will see to it that if you don't confess the crime you have committed, your family will be eliminated. Your house, you will be put in difficulty. I will get your family people arrested. ये सब threats देंगे तो आदमी डर के मारे yes मैंने कर दिया है. That is the job of a court to ascertain this. The police officer may bring before the court of law he has confessed. There are extrajudicial confession which are recorded otherwise than before a magistrate sometime. Some person, at a time, magistrate may not be available to record the evidence. So the evidence was recorded in the presence of somebody who is not a magistrate. It may be a police officer. It may be some doctor, some nurse. Some cases the court will have to see such confession with great circumspection and caution. In many cases, it is the surrounding circumstances of various factors, because normally, principally, in the matter of confession, the court is drawing inferences. Please note that it's basically a presumptive evidence. What is the compelling necessity for this man to admit the crime? What are the factors? What was going on in his mind? So all the evidence which you learn under section 8 and section 14 will come into play here. Facts showing the existence, his state of mind, his bodily feeling, what was his intention, whether he was compelled to do that, what was the mens rea present in his mind. ये सब चीजें देखेंगे कोर्ट. The motive, preparation, conduct, ये सब चीजें the court will ascertain the entire facts. So the evidence, the confession which has been recorded, if the court is of the conclusion that here it has been given on account of inducement, promise किया उसको कुछ पैसा, लालची दिया और threat दिया, धमकी दिया मारने की, a criminal intimidation, family को wipe out करने के लिए, or a promise, future promise, I will see to it that your family is prosperous, your children are sent to medical college, फाइनेंशियल हेल्प दे देंगे आपको, एडमिट करो क्राइम को. So some witnesses, such persons may be given such kind of promises. Whether court, it is a duty of a judicial mind to ascertain this fact, whether it is caused by inducement, whether it is caused by threats, or whether it is caused by promise. Then having reference to the charge against the person. So what is the nature of a charge? Whether he is convicted, whether he is being tried for a murder, whether he is being tried for a rape, robbery, the reason, who are the person holding some enmity with the gang war, some economic crime, ये सब चीजें ascertain करेंगे. Who are the person who could have given in the promise? Who are the person who could have given in the threats? Who are the person who are involved in the matter of such inducement? ये सब चीजें court will take into consideration at the time. Then reference the charge against the person, proceeding from the person in authority and sufficient in the opinion of the court to give the accused person grounds which would appear to him reasonable for supposing that the making of the supposing that by making the confession he would gain an advantage or avoid an evil of temporal nature in reference to the proceeding against him. So this section 24 in fact proceeds with a negative covenant. Mean the court should not allow evidence of the nature confession which is tainted with promise, which is tainted with inducement or threats. It is the duty of the court to ascertain whether the statements which are made are the exculpatory evidence are free from freely made, whether voluntarily made, whether under threat, whether they are can be taken into consideration or not. So, यहाँ पे section 24, there is a very strong, potent weapon for a defense lawyer to take the plea. All this on the ground that here the evidence, the so-called confession, merely because you're retracting a statement, a confession is not binding upon the court. Sometimes retracted statement advocate ने instigate किया होगा, but advocate should lay the foundation that the particular inducement, that the particular confession which has been recorded is not voluntary. He was under constant mental tension, and he was given retaliation. He was told that if you don't make this confession, we'll wipe out your entire family. He was under fear. He was afraid of his family, his wife and children. ये सब चीजें, the court will see the surrounding circumstances, the intention of the parties, and draw the inferences in the matter having regard to the nature of the charge, the position of the parties, both the accused person and the complainant, and the persons involved in the matter. It's a very major role, a big role the court is playing in this matter. The court has to ascertain whether the statement of confession is an exculpatory confession or it's an inculpatory confession. Because the evidence act doesn't define best part of it here. What is a confession? Confession is a statement which a man admits, owns his crime. Under what circumstances, what was his state of mind? Why is he doing this, man? ये सब चीजें सेक्शन 24 के अंदर लिखा गया है, प्लीज. सो दिस इज safeguard is not a complete blanket protection like under article 20 subclause 1, 2 and 3 के अंदर वहां पे blanket दिया है. A police officer cannot criminate a man, he cannot be compelled to give evidence. वो अलग बात है. यहाँ पे the man is charged, the charges are framed against him, and he has been brought before the court, and before the commencement of the trial, he wants to make certain confession. These safeguards. So that is a very important, vital piece of evidence before the court of law in a judicial. Yeah. So the confessions can be, there are judicial confession and extrajudicial confession. A judicial confession is a confession recorded before a judicial magistrate under section 164. Extrajudicial confession are recorded before a persons other than a magistrate. So you will come to know from the various judicial pronouncement of the Supreme Court, ये सब चीजें क्या है. Of course, the Evidence Act is not telling you bare act. What is a judicial confession? What is extrajudicial confession? आप judgment पढ़ेंगे, commentary पढ़ेंगे, और some textbook पढ़ेंगे, इसमें मालूम पड़ेगा आपको ये. Okay? Yes. Yeah. Yeah. So you understood the scope of section 24. So you should know that here section 24 speaks of the confession. Confessions are of two types. One is a judicial confession, which is recorded under 164 before a judicial magistrate, and not before an executive magistrate, and not before a DCP who is also act sometime as a magistrate. It must be judicial magistrate first class, a judicial magistrate second class, a metropolitan magistrate in city of Mumbai, a judicial magistrate in Pune or cities like Delhi, Calcutta and Madras, who are the persons who are capable of recording evidence. What is mentioned in section 6, 7, 8 ke andar, how the magistrates are defined, classification. Then extrajudicial confession, which is recorded before like persons other than magistrate. It's a weak evidence. But it doesn't mean that the court will completely disregard it, completely wipe it out. An accident witness who is brought before a hospital, there is no magistrate. He makes a statement, I was knocked down by this man. I had an enmity with him. I was crossing the road deliberately. He knocked me. He is my enemy in the businessman. समझे ना आप, evidence will lead to that here. कार नंबर सो एंड सो जानबूझ के मुझे मार दिया गया. He wanted to kill me, eliminate me. So the investigation will lead a car number kiski thi, kya tha, what was the reason for knocking him down, that person, whether he had enmity, whether any quarrel, any kuch, something retaliation, whether he wanted to do, all inquiries will start. So if the court finds that here, yes, there is some substance here, the reason why he was knocked down, and the confession is made before a magistrate, not before a magistrate. There was no time to bring the magistrate, and he was brought before a doctor in the EPR report, emergency patient report ke andar, before the nurse is taking, and the senior surgeon is asking him question, and by the time the police officer present here, who brought him here, extrajudicial confession is made. Certain times it can be accepted. It all depends on the nature of a case, nature of allegation. Okay, extrajudicial confession is also at times, though it's a weak evidence, but it cannot be totally neglected. Okay, then there is also evidence is called a retracted extrajudicial confession. So at the time you present the bail application, your counsel will say, the custom officers, the NDPS officers, they have a right to record your confession. And the confession made under this legislation is supposed to be, they have powers. A custom officer is not a police officer. So the Supreme Court says that here, but the Supreme Court will receive the evidence with a pinch of salt, doesn't trust because he the investigation officer himself. Under the NDPS Act, Section 67 containing that here, the man is making confession with regard to certain narcotic which he has eaten. But strict measures are required to be followed under Section 50. There must be the presence of a magistrate or some gazetted officer. Now, the Supreme Court judgment said that here a confession which is made under the NDPS Act, though the Act is no, but according to the Supreme Court, it's a confession not admissible if it is made to before a investigation officer. So that is a trend now here. So that statements which are made by the accused person, maybe at the time of the bail, sometimes your bail is not granted to you. Your bail is a matter of right in many cases, but in cases of serious offences under the NDPS Act, under the economic offences, अभी ना यूपा उपा के अंदर अनलॉफुल एक्टिविटीज एक्ट, वहां पे आपको बेल कहाँ मिलता है? वो बोलेंगे हमारे पास कन्फेशन है इसका. A confession है, but he will retract the confession through his advocate or counsel. He will say, my lord, here my confession has been recorded not voluntary. It is inducement. Threats of dire consequences have been given to me. The court may consider this, may not consider this at this stage, but at the trial, the court will see whether just because you're retracted doesn't mean that you're suiting your convenience. It will be done. It's a shrewd ploy of a seasoned advocate with a view to secure bail or with a view to put him out of the clutches of the punishment. He will take up the plea. I am retracting the confession. So there's a retracted confession, which you should know that where they normally every criminal lawyer who is practicing what is salt does that. You had to do this when you come in the criminal forum, when you present an application. And normally you cannot say that my client is admitting the crime and grant me bail. No, you have to say that the confession which has been recorded is forcefully. It is not voluntary at all. My liberty is sought to be curtailed, and the police officer acted high-handedly, the investigation officer, and my statement has been recorded erroneously, incorrectly. I retracted it. समझे ना, ये सब चीजें आते हैं. Yeah, retracted statement. Yes. So that is section 24. 25 में आ जाइए अभी. Yeah, anybody who wants to ask any question, 24 I can detain for 1 minute. Then otherwise you proceed to section 25, which speaks a confession to police officer not to be proved. A police officer being a investigation officer in the crime, no confession made to a police officer shall be proved as against the person accused of any crime. A police officer cannot claim, अरे accused मेरे को accept कर लिया प्रेम. Tomorrow Times of India के अंदर you will find a statement of a police. I have taken him into custody within 24 hours. Even I brought him before the magistrate. He says मैंने गुनाह कबूल किया. You will find in newspaper. Is it binding? No. It's not binding. A police officer being an investigation officer, he has no right to record confession. He has to abstain. The law is treating the police officer's evidence with suspicion, because a person who is conducting investigation is interested in putting him in jail and record his conviction to prove he's here. Of course, the Supreme Court says in many cases, public prosecutor is a friend of a court. And it's the duty of a police officer to place correct facts and not to take up anybody's side. Similarly, an advocate is an officer of the court, uh, and he has to assist the court, whatever may be the interest of the client. But that is not done. Quite practice may absolutely it is ulta. It is totally people take a somersault. If you come and see the court of law, how things go on, the police officer, the public prosecutor, defense counsel, all of them become very, very personal in the matters. Many of them, with the law says, whatever the law says, you should not be, should detach from the matter, but they are attached. For what purpose they attach? They want to prove their point. They are right and they are wrong. So there is any attempt on the court. The court is puzzled. Court feels that sometimes we are on trial. And nobody is telling the truth, neither the prosecution nor the defense. So it looks like it is the judge who is on trial. So many of the judges have passed these comments. So instead of assisting the administration of justice in arriving at good evidence, the public prosecutor, the defense counsel, the police officer, they botch up the case. So it's very unfortunate. You find lots of conviction rate is very poor in POSCO crime. Conviction rate is very poor in several crime, because the police officer has not conducted a proper investigation. And they don't have proper equipment. Many of them.
Sir, we have two questions. One is from Kedar. He has asked, in case of a remand,
Mm,
if a accused makes a confession to the police that he accepts the crime and
mm,
he is sent to judicial custody,
mm.
can he withdraw his confession at the stage of trial?
100%. 100% he can withdraw the confession that is not voluntary, because it is made to a police officer under the stage of a remand and prompted by the police before is it making it before a magistrate at the stage of a remand? At the stage of a remand comes into play under 167 2 CRPC, the magistrate is coming into play. Under what circumstances you made is more important. At the investigation you made it is not admissible. But at the stage of remand, the judicial officer is applying his mind under 167 2. But a magistrate will separately make it. Openly, nobody makes confession. The magistrate will call him in the chambers, will advise him not to make it. These are the safeguards which the magistrate has to comply under. But merely making in the open court, yes, I have committed the crime, I don't think it's a confession. It's a confession. It's not a confession. You are, under what circumstances you made it is required to be proved. So you are making a statement when a police officer is behind you, your hands are under cuff, and the magistrate is samne. So very the voluntary nature. You are under fear. You are making. समझे ना आप? You are not been brought separately to the chamber of a magistrate. Magistrate is separately required to hold him take him in his chamber. And at the time court के अंदर nobody should be present. When 164 his statement is being recorded, please note that here, because there should not be any outside influence. But at the time of the remand under 167 2 CRPC, line लगी होती है magistrate के पास. There are hundreds of people, 4-5 police station. आप 4-5 पुलिस स्टेशन के लोगों के सामने क्या एडमिट करेंगे आप? So in my opinion, certainly it is not a confession. So the man can say that here foolishly you made the statement, that statement is not binding on you. At the stage of the remand, the police officer is standing. Boliye. Next. Is that clear?
Sir, one more question from Utpal. He has asked, what is evil of temporal nature?
What is? Evil.
Evil of temporal nature.
Evil.
Yes, sir.
Evil
Yes,
of
evil of
temporal
temporal.
nature. कहाँ से मिला पूछो उनको ये?
Sir, Utpal is asking. I'm not sure.
उत्पल कहाँ से
So
लिए?
this,
ये
so this is mentioned in
this expression is finding in many judgment, but from where you found it and what context?
in section 24 itself, sir. In the last line, it says to or avoid any evil of temporal nature in reference to the
Evil of
proceeding.
temporary nature. Yes. Yeah. But yeah.
Sir, the sentence says, sorry, the sentence says that proceeding having reference to the charge against the accused person proceeding from a person authority and sufficient in the opinion of the court to give the accused person grounds which would appear to him reasonable for supposing that by making it he would gain any advantage or avoid any evil of temporal nature in
Yeah.
reference to the proceedings against him. Avoid evil of temporal nature. What would be a evil of temporal nature? That is the question, sir.
Evil of temporary nature means the consequences which may flow against his confession. If the court accepts his confession, they will be of dire consequences. But if the court doesn't accept because section 24 puts a break on him. So the confession which you are making, which is tainted with promise, which is tainted with threats, which is tainted with the inducement, they are colorable, they are sham, they cannot. So in that particular, the court may have made it here, maybe wanting to convict that man, but he has retracted the statement with your view to avoid the temporal nature. That particular passage which you are reading, it looks like the learned judge was wanting to convict the man on the basis of his conviction, but he has taken a defense that my confession is tainted with confusion. It's of a temporary nature, but ultimately there is no escape from convicting him because I hold his conviction to be proper. You read the judgment properly, you come to know the learned judge is not convinced by his retraction. The learned judge is to be convinced that the confession which he has recorded is proper. I mean, it may have been given before a magistrate. It may have been given by a judicial officer who has recorded it. So that particular, in that context, that judgment which have been made, so by just reading one line, you won't understand, but you have to read the entire judgment. I mean, an evil of temporary nature. So it is not a evil of temporary nature. You have to eradicate the evil totally. Either you eradicate the evil totally by accepting, but the court feels that you are using it as a shield to prolong the ending, to prolong the matter, and the court may give a finding. The court is finding in that particular case, maybe it's a temporary nature. That is what in that context you read the judgment and pass it on to me. What reference you read it here, I will read the judgment and discuss with you again.
Thank you, sir.
Okay. Yeah. Next quick question now.
Sir, can you retract the statement confession made before the judicial magistrate under 164 CRPC?
Yes, there is no bar. You can retract it because I was not in a good state of mind. I did not know the consequences. I was suffering from a particular mental disease. I was depressed. I was compelled to make it. There is no bad. But the court will examine whether your confession was correct, your retraction is correct. उसके लिए भी evidence. The court will find out the motive, preparation, and conduct utilizing your evidence under section 8 and your state of mind under section 14. No, what is ill will, good will, whether you are convinced or not, under what circumstances. Court will also find the corroboration. There's a corroboratory evidence here. Other witnesses देखेंगे. The reason for acceptance. Of course, naturally, when you are given, when you under the CRPC under 306, 307, you naturally make confession that you are ultimately let off. But if the court finds that you are not assisting the court properly, that confession, the concession which is given to you can be withdrawn. That is not to be read here. There you cannot be convicted. You are an accomplice. Accomplice who has been given a pardon, you are also making a confession. This is all exculpatory statement implicating yourself and implicating the others. If you don't implicate yourself, that is not a confession. Confession must be exculpatory, mean must include you in as an offender. Not inculpatory. Inculpatory mean that putting you out of the clutches of the crime. That is no confession. But there are cases where confession has been withdrawn on the ground that the man was not in a sound state of mind. The magistrate had not found it out. The medical evidence shows that he is suffering from so many diseases, depression. And there are possibilities that it is come on record. Subsequently, the police officer has given threats. There are letters come on record. The prosecution may say that my wife has received letter from the police officer. Ask your husband to come confess it, otherwise I am going to wipe out your family. So wife coming and giving evidence, a letter may dikha you. So it is a good ground for withdrawing the confession, isn't it? There are many police officers who write letters to the family members. See to it that your husband gives evidence this way, that way, that way. Your husband or wife, whoever is involved in the matter, son. Otherwise, he will face the music. So in such a situation, the confession can be retracted, not bad. So the grounds are given in 84 ke andar of the IPC ke andar. When you are suffering from diseases, when you are not in a stable mind, and it is not a voluntary confession. You made under some compulsion, some inducement. You prove it. You have to lead substantive evidence with regard to inducement. The onus is upon the accused person, the family members of the accused person. So the burden is shifting here. Please note that here, when you take up the plea that inducement was given to me, threats were given to me, the accused has to discharge his onus. The family members, a corroborative evidence will be led. There is no bar as such, but if the court will decide whether the retraction is correct or not, it is not our function, your function. The court will decide it from the having regard to the nature of the evidence before it, having regard to the nature of charges which are brought before it, having regard to the nature of other incidents. Several other factors are there, cumulative factors. Okay, that is section 24. 25, the police officer, 25 tells you that the accused offense, the police officer ke paas jo bhi confession cannot binding. Police officer not the authorized person to record confession. So 25 completely puts a blanket ban. There is no need to prove it. A police officer cannot be permitted to lead evidence. ये आदमी admit किया करके. Section 25 is a bar. So the legislature is completely prohibiting the police officer to rely upon the so-called confession made before him. You are not competent. You are not qualified. So how can you take up the plea? So 25 is a complete ban. Okay, especially in the Indian Penal Code, but other offences, the courts are a subject matter of discussion and NDPS में एक्ट होता है, उल्फा में क्या होता है, सेंट्रल एक्साइज कस्टम्स लॉ के अंदर होता है, वो अलग. So we are now confining to the Indian Penal Code cases where the magistrate. Yeah. 26 में आ जाइए. Confession by accused while in custody of a police not to be proved against him. तो यहाँ पे during the stage of the investigation, confession to the police officer not to be proved. तो यहाँ पे custody में आ चुका है. So the police officer has arrested him under the provisions of section 41 of the CRPC. So the stage is he is being brought to the kept in judicial custody or maybe magisterial custody or a police custody. He is in custody. Which custody he is in? So he will be in a police custody between the period section 41 CRPC से लेके 167(2) में he will be before the police officer. The moment is brought before the remand application, and remand 15 दिन तक magistrate can keep him in police custody, isn't it? The maximum period section 167(2) CRPC permits the police officer to keep the custody is 15 days. After 15 days के बाद, the custody becomes judicial custody. All of you know that here. Section 167(2). Now, he is in the police custody, not to be proved against him. So this is a stage of a क्या नाम बोलते हैं, pre-remand stage. 26 speaks of a pre-remand stage. Maybe he is arrested in Nepal. So a crime is committed in Bombay or in Mysore or Bangalore. 3-4 दिन लगेगा produce करने. So traveling period is excluded. All of you know that. Article 20T को हिसाब से भी, and section 57 CRPC also tells you the traveling period is excluded. Okay, वो exclude करने के बाद, then say no confession made by any person while in the custody of a police officer. So he is still in the custody of a police officer. Maybe he is brought for remand after arrest within 24 hours. The magistrate has granted police custody remand for another 7 days. So he is considered to be in police custody. Then, यहाँ पे, unless it is made in the immediate presence of a magistrate. So at the time he is brought before a magistrate. So your question is here, somebody asked me first question. If before the magistrate he says confidently, yes, I am brought it here, and I have made a confession, I want to write something. Yes, I agree that I have done the crime. Shall be proved as against such person. So even at the stage of a remand, when a judicial magistrate is taking his remand under section 167(2), provided he is not under inducement, please note that here, just because he is produced before a magistrate, the confession doesn't become judicial confession. The onus still upon the police officer, because the police officer is hanging like a Damocles sword behind him. पीछे ही खड़ा है वो गन लेके और under handcuffed है. If you make this confession to a magistrate, what is the extent of evidentiary value of this evidence? So the law is saying it can be proved, not must be proved or it will be proved. But again, the embargo contained in section 24 will apply. Embargo number one, that he is making the confession without any inducement, without any fear, without any promise, fearlessly. But when he is a handcuff, when the police is stationed there, you have a defense to argue. By no stretch of imagination, the confession can be called free confession without from bias. It is absolutely tainted with consideration. His mental state did not permit him to do this. He was a frustrated person. He wanted to finish. He was under the impression, my confession कबूल कर लूंगा तो कोर्ट में छोड़ देगी जल्दी से. He was under the wrong impression. That are the defenses, you can take it up. But the man persists, नहीं मैंने गुनाह कबूल किया है, मुझे मंजूर है, मुझे जेल में भेजो. Then that's a different matter. Then his confession can be kept aside when it will be used against him when charges are framed under 211 to 219. Charges framed करने के बाद, whether it's a session trial, whether it's a warrant trial before a magistrate summon trial, at the time plea will be, when the court is framing charges or recording a plea, the court will ask him, क्या गुनाह कबूल है? The second inning is played, no? Isn't it? The second inning after that. So look here, at the time when you are brought before the magistrate, आपने बोला कि गुनाह मुझे कबूल है कि अभी क्या कहना है आपको? अभी मैं चार्जेस फ्रेम कर रहा हूं, आपकी चार्जशीट फाइल हो चुकी है, कॉपी मिलेगी क्या आपको? The police officer under section 173 has to file the charge sheet after forwarding the accused under 170 CRPC. Then also comply with the provision of 207, 204, furnishing the copies. ये देने के बाद मजिस्ट्रेट का रोल होता है, it's a committal proceeding. Even under 209, he will send it to the court of session. Magistrate has no right to record plea or a confession, only plea or frame charges when it's a session triable case. The learned session judge will ask him, at the time you are brought before the magistrate, namely for remand, आपने कोई स्टेटमेंट किया था क्या उधर? अगर वो बोलेगा मैं नहीं किया था, मुझे याद नहीं, then it's suspicious confession. The court may remind him, look here, तुम्हारी ये राइटिंग है क्या, आपने किया, साइन किया है क्या? मुझे याद नहीं, या मैं किया है. If he reiterates, मैंने किया है, मुझे गुनाह कबूल है, the magistrate will record the session judge will record a plea under the provisions of section 225, 226 CRPC and say that yes, evidence the accused is before me, produced before me in a court of session, and he is taken in custody, and I will keep the matter for pronouncing judgment and sentencing. Then he will hear both the parties, the prosecution as well as the defense, what should be the punishment in that regard. वो separate charges होने के बाद, plea record करने के बाद, the court will have to consider whether this man has made this statement. So yes, section 26 ka role is a little more dangerous and dicey. It is not that easy at RPS to be. But the role of a judge increases. So he may be recording it, but at the time that doesn't dispense with the requirement of framing charges. If there is it's a warrant triable case, he has to frame charges. And if it is a session triable case, he has to commit the matter to the court of session, furnish documents under 206, 204 and 207, copies देना पड़ेगा उनको. Then he is produced before the court of session and he is asked to please record it. Please say पहले charges are framed by the court. Court will frame the charges, frame करने के बाद, then the court will ask him, गुनाह कबूल है आपको, you want to admit the crime or no? Then that is, you learned it last year. So I would have been happy if the CRPC and Evidence Act and CPC kept in one session. But तुम लोगों को अलग अलग कर दिए हैं, जुदा कर दिए हैं. CRPC, CPC, one first session, Evidence Act separate. So you don't understand much better. So according to me, the examiner university should keep these three subjects together. All these are procedural law and substantive law with regard to evidence, and CPC, CRPC should be understood at one time. That will go better in your brain. You will be a better lawyer. But वहाँ पे जुदाई होगी. पहले फर्स्ट सेशन में CPC और CRPC, अभी लास्ट सेशन में आपको एविडेंस एक्ट. Many of you, it's difficult to remember, because your subjects are so many vast. Half of the people will forget what is mentioned in the CPC, what is mentioned in CRPC by the time you start reading Evidence Act. Okay, that is different, but you have to do a revision job. So don't give up your CPC and CRPC while understanding Evidence Act. Please note that. Your procedural laws like CPC, CRPC must be known to you even now when you are tackling the Evidence Act problem. Okay, that is the stage here. Section 26 will come into play. So it has two requirements, the two inbuilt requirement here. Number one, a confession made by a person while he is in custody, a police officer, is not binding. Then use the word unless it is made in the immediate presence of a magistrate. So immediate presence of a magistrate, whether the surrounding circumstances, the court crowding permitted the magistrate to record, the magistrate is sitting with hundreds of people, or did the magistrate told everybody, that is to be seen. when you are a defense lawyer, to find out, did the magistrate record a finding statement that the accused want to make a statement, confession? Did the magistrate take him to his chamber, or did the magistrate vacated everybody from the court? Huh? Was that person alone? Because the safeguards of 164 will come into play. Just because 26 cannot be read in isolation. It has to be given harmonious interpretation, should be read in conjunction with 164 CRPC. Magistrate should warn him, look here, gentlemen, you cannot make confession. You will land in trouble. I hereby warn you not to may do that. And if you make it, you will go to jail. I am telling you, don't make it. If despite my warning you want to do that, I don't mind recording it. Look here, this is. Magistrate should find out what is his state of mind. Magistrate के पास उस समय, especially when sitting in remand, where does he have time? You come into the remand court, it's overcrowded. It is like a fish market. Unfortunately, the magistrates are overly busy with the work of 5, 6, 7, 8 police stations. Those of you who are visiting a magistrate's court will come to know this. So unless the learned magistrate takes precaution to disperse everybody, takes him in chamber, a procedure is a difficult procedure, but it is not impossible. It can be done. Okay, it can be done. So I gave you illustration here. When he's under 41 के बाद arrest होने के बाद, he is produced under 50, exercise under 56, 57 CRPC read with Article 22. Within 22 hours, within 24 hours, is brought before a magistrate. So at the time, the learned magistrate is extending, granting remand, whether to police custody or a jail custody. Maximum period 15 days we can give the police officer. So thereafter he has to commit him to judicial custody. 15 दिन के बाद. So under which custody, where he's made a statement, it's a matter of interpretation. Explanation पे आ जाइए. In this section, magistrate does not include the head of the village discharging magisterial function in the presidency of Fort, St. George, elsewhere, unless such headman is a magistrate exercising powers of a magistrate under the Code of Civil Procedure. So for the purpose of 26, so magistrate definition काफी है. There are magistrates, executive magistrate, people, peacekeeping for क्या नाम है, magistrate who are even a police commissioner is a magistrate. And collector is a magistrate for the purpose of section 144. Those magistrates are not magistrate for the purpose of confession. A judicial magistrate. A judicial magistrate who is capable of recording evidence in a judicial proceeding. To our CRPC के लिए कहता है what is a judicial proceeding? And the provisions of एक minute. Yeah, those of you have 1 minute. So when you open your CRPC, you will know the various types of magistrate. Section 8, 9, मेरे ख्याल से है ना, isn't it? Classification of court check करें, उसके अंदर magistrates हैं. Judicial magistrate first class, judicial magistrate second class, executive magistrate. Fourth number. So executive में आ जाएंगे, collector भी आ जाएंगे, आपके police officer भी आ जाएंगे. There are magistrates who are sitting retired gazetted officers. They don't come within the category of a recording judicial confession. So the 164 खोलेंगे आप CRPC के अंदर, you will section 164, who are the magistrates exactly pinpointed यहाँ पे 164. Yes. Recording of confession and statement. Any metropolitan magistrate. तो मेट्रोपॉलिटन मजिस्ट्रेट का डेफिनेशन आपको मिलेगा सेक्शन 8 के अंदर, सेक्शन 8 ऑफ द सीआरपीसी मिलेगा इसके अंदर. एनी मेट्रोपॉलिटन मजिस्ट्रेट और जुडिशियल मजिस्ट्रेट So even judicial magistrates are mentioned under the provisions of section 7, section 6, 7, 8 and the provisions of Court of Judicial section 11. Section 11 CRPC tells you who are the judicial magistrate, unka kya rank hai. And 12 speaks of chief judicial magistrate. Then 13 speaks of special judicial magistrate. So these are the magistrates who can record evidence. These are the evidence. These are the magistrates. Section 164. Any metropolitan magistrate, judicial magistrate may, whether or not has jurisdiction in the case. So it doesn't mean that it is not trying a case. For trying of a trial offences under the CRPC, the crime should have been committed in a particular area. And the consequences must have been flown in a different area. So only those magistrates can take up the matter that you know that you learned it from the provisions of jurisdiction of the courts under the CRPC, which is given to you when you see that relevant provisions, section 177 onwards. Ordinary place of inquiry and trial 177, place of inquiry. This has nothing to do. That is chapter 13 of the CRPC tells you the jurisdiction of the magistrate, the sessions court and the high court, various courts within what they can do. No, here here the law mandate that you should go to a particular court where the offense is committed, a particular police station. But 164 doesn't require that. Here your crime may have been committed in Delhi. Confession can be recorded in Mumbai or Calcutta or in Banaras, because it is ultimately the designation of the officer is counted, isn't it? Statement to him in the courts of a metropolitan magistrate, he has a jurisdiction in the area. Whether or not he has jurisdiction, it is immaterial. For the purpose of recording a confession, no, it's not necessary. Jurisdiction is not counted. Yes. Any confession statement made to him in the course of an investigation under this chapter, under any of the law of the timing in force, or any time afterwards commencement of the inquiry or trial, provided that the confession or statement made under may also be recorded by the audio, video, electronic means in the presence of a advocate of the accused person. Now, under the POSCO Act and the crime against women, it is being done nowadays. Please note that recording of evidence here, this has started with effect from 2009 amendment. So this is more authentic now. So the only condition is that you have to, when you record it in the audio conference, video वगैरह, section 65B का procedure follow करना पड़ेगा. Isn't it? That is under the Information Technology Act के अंदर. Provided the instrument is not original. Next step. Provided that any confession statement made under the subsection may also be recorded by audio, okay? Then provided further that no confession shall be recorded by a police officer on whom any power of a magistrate has been conferred under any law of the time. So there are many police commissioners in Mumbai, elsewhere, Delhi, har jagah. The collectors, they are given powers of a magistrate. Under chapter proceedings under the Bombay Police Act, extendment के लिए, a police commissioner is a magistrate. 106 proceeding for a breach of peace के लिए, magistrates are trying, the police commissioner tries these matters. So before him, if he makes a statement of confession not binding, please note that they are magistrates are not called. Judicial magistrate, who is a judicial magistrate under the CRPC, you read it out and know. Judicial proceedings which are mentioned in under section 2 of the CRPC, where the evidence is recorded by the Evidence Act is applicable, not before any Tom, Dick and Harry. So what is a judicial proceeding is given to you. Section 2I include proceeding in the course of which evidence or may be legally taken on oath. यहाँ पे दिया गया आपको. Then further 164 says, subclause 2, the magistrate shall, before recording such confession, explain to the person making it that he is not bound to make the confession. See the safeguard. For the purpose of invoking section 26, it is not so easy. Remand के time पे कर देंगे. Provided these are the, when your defense lawyer देखेंगे, the magistrate is enjoined with a duty to explain to the person making it that he is not bound to make the confession. And if he does so, he may be used, it may be used in evidence against him. You can be convicted, you can be sent to jail. Magistrate shall not record the confession unless, upon questioning the person making it, has reason to believe that he is being made voluntary. The magistrate, a subjective satisfaction must be recorded. The magistrate must record a finding. I have thoroughly investigated the matter. I have examined the situation. I have given him an opportunity not to do that. I am satisfied. This man wants to make it out of his own enthusiasm. ये लिखाएंगे magistrate साहब voluntarily. So he has to use it. There is no force, there is no compulsion. There is no presence of a IO at the time. There is no presence of any witnesses. Nobody is alone. ये लिखाना पड़ेगा. Subject to provided his own advocate is there. वो audio video में recording हो रहा है. Of course, his own advocate will not give evidence. Okay. Then 3 देखिए. If at any time before the confession is recorded, the person appearing before the magistrate shall, he is not willing to make any confession, magistrate shall not authorize the detention of the person in police custody. See that here? He is not willing to make confession. The magistrate shall not authorize detention of such person in police custody. उसको immediately judicial custody में लेकर आना चाहिए. Because police will hammer him. मैं तुमको लाया था मजिस्ट्रेट के पास बोलने के लिए, गुनाह कबूल करने के लिए, और चेंबर में जाके बोला तुमने मजिस्ट्रेट को मुझे कन्फेशन नहीं देना है. So naturally the police officer will be infuriated. He will be गुस्से में, he will लाल हो जाएगा, isn't it? You will see the indignation on his part. He is also a human being. That I tutored you, trained you, ऐसा बोलने वैसा बोलने के लिए, और चेंबर में जाके बोलता है तुम कि कन्फेशन नहीं करना है. So the magistrate must presume that a person who comes to the chamber or brought by the police officer for the purpose of recording confession, he declines to make confession, the magistrate should not entrust his custody back to the police. इसका मतलब, don't trust the police officer. It is human nature to retaliate. Police officer will hammer him out. So इसीलिए put him in judicial custody. This is, please note that, magisterial custody where there is no intervention of the police. Police officer cannot go there without the permission of the magistrate. So very beautiful. This safeguarding his liberty of the accused person under Article 21 of the Constitution. His right is being protected under fundamental under Article 22. So this you remember it very well. Please note that here. Yeah. Then number 4 पे आ जाइए. Any such confession shall be recorded in the manner provided in the section 281 for recording examination of the accused person, and shall be signed by the person making the confession, and the magistrate shall memorandum of the fruit so and so. एक memorandum तो बताया मैंने आपको section 80 में evidence है. Now under the provisions of section 281 हमने पढ़े थे while recording evidence, inquiry 281 के अंदर that is the record of the examination of the accused is maintained by the magistrate under the provisions of chapter 13, that is evidence in inquiry and trial. 281 says, 281, whenever the accused is examined by the metropolitan magistrate, the magistrate shall make the memorandum of the substance of the examination of the accused in the language of the court in Marathi, Mumbai, in other North India में हिंदी में भी कर सकते हैं आप और English में भी कर सकते हैं, whichever part of India, and such memorandum shall be signed by the magistrate from forming the part of the record. Magistrate has to sign this memorandum. This memorandum becomes evidence under section 80 of the Evidence Act. The court shall presume that this is correctly recorded. Number 2 check करें आप. Whenever the accused is examined by the magistrate other than a metropolitan magistrate or by the session or the whole of the examination, including any question put to him and answer given by him, shall be recorded in full by the presiding judge, magistrate, or where he is unable to do so owing to physical other incapacity under the direction, the superintendence of any other officer appointed by him in the custody. So if it recorded before a court of session, in what manner it is be done? A session judge need not sign it here because he is the superior officer, he is more trusted than by the judicial magistrate. He is more responsible man. Number 3, the record shall, if practical, be in the language in which the record is examined and not in the language of the court. It should be in the language of the accused as far as vernacular language is using. If he is speaking in the language is in own mother tongue, record karenge. Then the magistrate will try with the help of an interpreter, will record it in the language of the court. If it is in Maharashtra and Marathi, if it's in UP, it's in Hindi, if it's in Tamil, Tamil mein, Telugu, Telugu, Andhra mein, various languages are used here in that regard. Then 4 mein, the record shall be shown and read to the accused. पढ़ाना जरूरी है उसको accused को, लिखिए भाई आपने ये कहा था, हमने ये लिखा है. This is written down, or does not understand the language in which written shall be interpreted to him in the language which he understands, shall be at liberty to explain, add the answer. So he should be able to in a position to know what is written by him, what is stated by him. The court should make him understand, look here, you have made this statement voluntarily which I recorded. सबके तुम्हारे सामने लिखा है मैं. I want you not to make this statement. फिर भी आपने बोला है. This is what. Then number 5. It shall thereafter be signed by the accused or by the magistrate or the presiding judge. Even a judge is required to sign that here. Who shall certify under his own handwriting that the examination was taken in his presence and hearing, and the record contained full and true account of the statement made by the accused. See how this is beautifully worded. You cannot read this section 24, 25, 26 alone. You have to read it in conjunction with section 164 under the provisions of section 281, and I will come to section 80 also iske baad. Then subclause 6 check kare aap. Nothing in this section shall be deemed to apply to the examination of the accused person in the course of summary trial. समरी ट्रायल के अंदर जरूरत नहीं पड़ी, प्ली रिकॉर्डिंग करता है, एडमिट करता है, छोड़ देते हैं. बट वारंट ट्रायल के अंदर मैंडेटरी है, isn't it 6 के अंदर. So the provisions of section 281 are mandatory to be complied with the magistrate and the session judges before whom the evidence record. Now this memorandum which is recorded under 281, see that here you cannot read section 26 in isolation. 26 के साथ में 26 के साथ में you have to read 164 compliance of the CRPC, 284 compliance. Now ये 284 and 164 and statement made under section 26, how they become evidence. Please open section 80 of the Evidence Act. अभी पढ़ाता हूं आपको भाई, अभी बता दूंगा. section 80 खोल लीजिए आप. Presumption as to document produced on record of evidence. Whenever any document is produced before any court purported to be the record of memorandum of evidence. So 281 में अभी पढ़े हमने memorandum of evidence or any part of the evidence given by a witness in judicial proceeding. So including the evidence given by the accused while giving confession or before any officer authorized by law to take such evidence. or the statement of confession, underline this word, statement or confession by the prisoner or such accused person taken in accordance with law, taken in accordance with section 164 and 281 CRPC, and purported to be signed by the any judge or a magistrate or by the officer shall presume, the court shall presume that the document is genuine and the substance as to circumstances under which it was taken purported to have been made by signed by person or true and evidence statements confession were duly taken. So this is section 80 is directly brought and linked to section 4 of the Evidence Act, which says that here the court shall presume, come back to section 4 now, shall presume, whenever it is directed by this act, the court shall presume, shall regard such proved unless until disproved. So that means the accused person has the court normally presume the memorandum of confession is true, but the accused has the right to challenge it. Kabhi, when he files retraction. Retraction statement bolega the magistrate has not recorded correctly. So he has a right to call and cross-examine the magistrate. Please note that. Magistrate not exempted from evidence. They have to come and give evidence. If the accused person makes serious allegation, I never gave such statement. I was under duress. Mera mental condition ठीक नहीं था. They are not voluntarily. The learned magistrate was dictating as per the police statement. The magistrate was not fair. He was acting in a very arbitrary manner. He was not acting in a judicious manner. He was acting in a very injudicious manner. These are all open for you, these doors. So the accused person shall be entitled to lead evidence to disprove the statement, which is very, very difficult, but not impossible. Please note that. Anybody want to ask any question? Put lijiye. I think we can stop it here if it's too much for you. And next lecture Monday ko leta hu main. Anybody want to ask me any question?
Sir?
Yeah.
Sir, does section 25 takes in within its purview the statement confession made before police officer where the investigation or FIR has not been launched yet?
That is completely banned. Police officer cannot say all these statements. 25 statement, confession, FIR is not evidence. Statement recorded under 161 are not evident. They are subject to cross-examination. And FIR is not a substantive piece of evidence. Okay, 25 के अंदर आ गया ना, because these are all they are required to be proved before the court of law.
Yes, sir. Understood.
Section 161 is merely a statement and is not evident. 162, the police officer record only when a witness dies, then they come under 32. 32 के अंदर circumstances leading to the death. I will explain when I am dealing with you section 32. The reasons given by a person why he was dead. ये सब चीजें आ जाएंगे उसके अंदर. Otherwise 25 completely bang. 24 तो बंद ही कर देता है कि you cannot, these are the condition. These are the negative covenants against the prosecution. You cannot lead evidence of confession, which is a promise, which is tainted with the force in retaliation. And similar 25 कहता before a police officer lockup के अंदर मैं कबूल किया, it is not binding. It's ex fact. It is to be thrown out immediately, not to be relied upon. Confession made by a police officer in lockup or during the stage of a recording statement under 166 or 41, not to be accepted. So अभी under 41A के अंदर notice देंगे आपको police officer. बोलेंगे I am likely to I have received a FIR. Now I am under direction to record 498A के अंदर, you know that as per the Supreme Court judgment in many cases in Dalita Kumari versus state of UP, you cannot a police officer arrest in matrimonial cases ipso facto. 498A cases, civil cases, you have to give a notice. Of course, both civil cases and criminal cases run parallel together, isn't it? It doesn't mean it's a matter of a civil nature. A magistrate should not try. He can try. Sometimes there are parallel cases are maintainable. So when they are maintainable, evidence can be led both the ways. So, yes, anybody want to ask any question, please ask me. Next section, that is a 24, 25, 26 ले लिए अभी हमने. Then explanation में magistrate does not include the head of a village. वो भी सीख लिया आपने. Elsewhere, CRPC. Then yeah, 27 मैं कल लूँगा because a very important section. 27. Now 27 के अंदर certain statement recovery होती है, they become admissible. They become recovery 27, 28, 29, 30 कर लूंगा मैं आपको. Till 31 तक these are the admissions part. So the remaining part, anybody want to ask me question? This is a very important section, especially. Please also keep your CRPC along with you. Don't give it up. Monday का दिन मिलेंगे as usual time. No? So we can come. I'll finish my court matters and come early. 5:15, 5:30 will be ready.
So there was a question in the group, WhatsApp
Yes.
group on Wednesday, asked around. So the question was, can the court take cognizance of things which have not been brought as evidence to prevent miscarriage of justice?
See, Section 4 of the Evidence Act tells you it is not just the evidence before the court. All matters before the court. The definition of prove, disprove, not prove, check karo, open kare. Definition proved, not proved, proved, disproved, and not proved. Now, when you read this, everything will come into picture. A fact is said to be proved when after considering the matters before it. Underline the word matters. Any matter which is relevant can be brought. It may not be evidence. So I gave you illustration. A report of a commissioner appointed under Order 26, Rule 1 CPC. A report of a commissioner again, investigation agency under Order 39, Rule 7. They may not be evidence in their nature. They are a statement, a bailiff ka statement of a service. Something which is relevant, you can bring it. And Evidence Act permits also statements which are illegally collected. Certain evidence of, for example, you cannot tamper somebody's phone. Tape recording, secretly आपने recording करके produce कर दिया. So under one particular law, it may not be relevant. Under there is a bar. But Evidence Act is lifting all the embargoes. So, you know, R.M. Malkani's case, which I discussed with you, evidence of a tape record was collected and believed by the Supreme Court in convicting the coroner of Bombay for demanding money from a doctor. Similarly, in another case, where the landlord was convicted for trying to bribe the municipal witness, the evidence was collected against him. And the Supreme Court in Rafale's case gave a finding. Yes, the documents relating to Rafale have been stolen from the parliament. There's a leakage. It may be illegally done, but they are relevant. It is not come as evidence on record, but it is collected. It is relevant. Something which is relevant is can be considered by the court. So the definition of proved, not proved, disproved considers the court considering the matters before it. तो तीनों जगह अभी देखिए. Proved may be क्या? Considering matters. Disproved may be considering matters. So the court will consider not only the evidence, primary evidence, secondary evidence. Court will consider the presumptive evidence. Court will consider the various types of evidence, and even the matters before it. And a matter which is brought by somebody writes a letter to the court of law. This has happened. And court is appointing a commissioner for recording the commission in both CRPC and CPC. The demeanor of the witnesses is recorded. The witness was hostile, passing comments, adverse comment. They may not be evidence. They are all relevant. आपने पढ़े हैं ऑर्डर 18 के अंदर सीपीसी के अंदर also under the provisions of CRPC demeanor evidence can be it is not evidence but these are remarks which the court can take into consideration. When you open the provisions of section 272 onwards, that is inquiry and trial, आपने देखेंगे one particular section will find remarks relating to demeanor of witness 280. That may not be evidence. See, section 280 of the CRPC says 280. I will just read it for you. 280 खोल के देखें CRPC. Remarks respecting demeanor of witnesses. अब ये evidence क्या है देखिए. When presiding judge or a magistrate has recorded the evidence of a witness, he shall also record such remarks, if any, anything material respecting the demeanor of a witness while under examination. So section 280 के अंदर है, even when you open your evidence, the code of civil procedure code, मेरे ख्याल से order 16 खोलिए इसके अंदर, if I am not mistaken, and you must remember these are the situation which will come before the court, how the evidence can be recorded. If I am not mistaken, just open it, order 16 खोलिए आप, order 18, 16 or 18?
Sir, it's 18 rule 12.
18 rule 12 के अंदर खोलेंगे आप, the demeanor is recorded. So that is a matter before the court. Right now, order 26 rule 1 के अंदर, when you open it here, court is appointing commissioner, isn't it? The commissioner is giving certain findings. Order 26 खोलिए CPC आप, 26 के अंदर commission देखो, order 26 rule 1 के अंदर यहाँ पे commissioner भी record करता है. Commissioner is record to certain observation. And various, these are 26 से लेकर 10, 11, 26 तक है ये. So finding whether challenge, not challenge, ये सभी court will consider this. तो काफी लंबा आप चक्कर है इसके अंदर देखिए आप कमिश्नर के बारे में. 19, 20, 21, 22, 26A, isn't it? So these are all matter. So at the time when a suit is filed by you, writ of summons have been served. What did the certain defendants are unserved or avoiding services? Publication was given newspaper mein. Advertisement de gaya. Court is passing an order. Suit the defendants are not represented. Undefendants trial to proceed ex parte against them as undefendant. That observation is also helpful. That is a matter before the court. And nobody has come to give evidence on behalf of the defendant and undefendant. But the entry of the judge that the writ of summons have been duly effected. Publication has been done under order 5 rule 20 CPC. Personal service has been effected. Emails have been sent. No response. The court is passing order. This particular defendant number 1, 2, 3 to be proceeded ex parte and undefended trial to take place. So observation. So tomorrow appeal is filed. Bolege, he will take up the plea. I was not at all given a principles of natural justice. Bolega court, there is a evidence against you. You may not have come to the court. He may not have deposed. There is the entry of the judge. That is the entry will go against you. That entry may not be evident. It's a matter before the court. Chandana? So the question with the student asked me whether only evidence which is not before the court may consider it if relevant. The court को power है. You open section 165, how the court has power. Section 165 खोल लीजिए, Evidence Act. The judge can consider relevant, irrelevant. The judge may, in order to discover or to obtain proper proof or relevant fact, ask any question he pleads in any form at the time of any witness or a parties about the fact, relevant or irrelevant. Underline the word irrelevant. Parties are not entitled to give evidence on irrelevant fact, but the judge has a right to take into consideration and may order the protection of any document, thing, any neither parties or neither agency shall be entitled to make. So nowadays, Supreme Court may, High Court may, in these days, the fashion, court will tell you, give everything in seal envelope. That means you don't have the opportunity to see the other side. Our government pleaders are saying, my lord, this material is incriminating, I cannot reveal in public interest. Court क्या कहती है देखिए आप read the newspaper, you come to know. Give your submission paper documents which are in public interest in seal envelope. So that is an evidence. The court is perusing under 165. You are deprived of your right of cross-examination. You cannot. The court said that I have perused those papers. They are a material allegation and I will be using against them. That the court. So the power of the court is very wide under the provisions of the Evidence Act, CPC, CRPC. Of course, those certain things are silent. Inferences can be drawn by the court. Of course, the court will only give judgment on relevant fact. They see, provided that the judgment must be based on the fact declared by this act to be relevant. Though the judge has a right to peruse relevant and irrelevant document, but the finding of it, ultimately, judgment must be rendered only on the basis of evidence which is declared by the Evidence Act, section what is relevant, irrelevant, 5 से लेकर 56 के अंदर. उसी के ऊपर, within the parameters of the Evidence Act, you have to give evidence. So there is no bar, nothing prevent the magistrate or a judge in considering something evident which is not brought on record. Please note that, because section 4, for the purpose of proved, not proved, disproved, में क्या लिखता है? Considering the matters before it. It doesn't say considering the evidence before it. So that means the scope of the judge's inquiry is very vital. Any other question? समझ में आया है नहीं? Has the student understood? Oh yeah, somebody has asked. Yeah.
Understood. So
Yes.
just a quick question, if I'm not prolonging the session.
Yeah.
Sir, suppose your previous lawyer of a party makes some admission or some suggestion in the court of law, then thereafter they change their lawyer. Does those submissions or admissions bind the party in subsequent proceeding, or what is the remedy available to them?
Yeah, very good question you asked me. There are many judgments of the Supreme Court. The concession given by a lawyer against a party are not binding. But there are some judgments which take up the plea. If the concession is relating to law which is applicable and having regard to the evidence, correct, it may be binding. But mostly the court doesn't like to the confession which are exculpatory in nature, which implicates the person in a crime, are not accepted. Because the court will require a strict evidence and doesn't go by the confession of a lawyer. A lawyer's confession cannot, like a lawyer's mistake, party cannot suffer. Similarly, on the basis of a concession given by a lawyer, erroneous concession, the Supreme Court says, there are many judgments to the effect, the party cannot suffer. The parties have a right to challenge it. Because this particular instruction, I never gave my advocate to make it. He has made it. So not binding on me. So you can take out an application for review that this may be retracted. Of course, the court will definitely consider, there'll be a rehearing in the matter. There are many such judgments which have come, and even I have argued many such matters where the advocates have made parties mistake. Advocates cannot suffer. Many times appeals are filed belatedly. The client बोलते हैं मैं advocate को पैसे भी देके गया, paper भी देके गया. He has not filed. What I can do? There are one matter which went to the consumer court. Advocate took the money from the client and did not file the appeal and proceeding. And he went to Supreme. At the time in the earlier act, the consumer court court said that yes, the advocate liable to pay, compensate him, whatever done. There are erroneous concessions made in the court of law by lawyers with regard to the civil rights, constitutional rights. The judgments are there cannot be estoppel against the law. You cannot give up the fundamental rights your client is entitled to. If the CPC and CRPC giving you some rights to your accused person, Advocate cannot say, I do not want to accept that right for my client. So it is an erroneous concession. The law is giving you protection. You avail of it. Isn't it?
Sir, if I may request,
And
you
a
could.
witness is sick. And the advocate should know that you can record, evidence should have been recorded by commission. Advocate bolega not necessary. That confession is wrong. That concession is wrong. Boliye. Next.
Sir, if you could provide those relevant judgments in the group so that we can read them.
थोड़े मेहनत तुम भी करो भैया गूगल पे सब जजमेंट है
Oh,
I
sir,
can आप लोग भी
relevant
करो
statutory provisions. If you
I
could mention relevant
no,
statutory provision for research.
what point बताओ मेरे को on
Sir,
confession
on yes, sir, on this point, admission by previous lawyer, not binding on the parties.
that is there many there that is there Guru but I'll give you that
Okay.
is called a concession given by a previous advocate whether binding I will not say confession concession क्या
Concession it is.
concession.
Concession.
Advocate cannot make confession. Only accused can make. Civil law के अंदर there is no confession, only admission. So I will not call it confession. I will make it a concession. क्या?
Concession made by a
Concession.
lawyer, not binding on the
Concession.
parties.
Erroneous concession of law is not binding. If a concession is given which is true and correct, advocate has the implied authority. Please note that. An advocate is an officer of the court. If the court will see that, yes, this particular, you may have signed the consent term withdrawing the suit. And tomorrow say, no, I not given, my advocate has made a wrong statement. See, advocate also can withdraw the case. Abhi Supreme Court ne कह दिया कि in many cases the clients are taking up the plea. I never gave instruction. So they make it a present that your advocate should remain present and a party should sign the consent term. And many advocates appear without filing appearance in many cases. The practice is that here senior advocate need not file appearance. Advocate and record. Many advocate and record. Say, my lord, my client is out of India. I give undertaking that to file his appearance. Wakalatnama next time. Oh, file ही नहीं करता, चले जाता. The client will come and say that I never authorized him. So these are the concessions and confession. Concession. I never gave him power to withdraw my case. Fraud has been played upon me. My advocate is colluding with the other side. You can file a suit. It is all depends what kind of a stand you want to take. So the judge will decide it, whether the nature of concession given by a lawyer and the standing of a lawyer and the nature of the suit, the court will take it to consideration. And you know that one senior advocate in the Supreme Court, less said the better, having a senior gown, he did a shameful act. He told the other side, phone उठा के 2 crore रुपए मेरे लिए रखना. I will settle the matter in your favor. You know that? He's a shameful, very shameful advocate. He appeared for many political parties and Prime Minister of India, ex. Of course, the Supreme Court did the right thing by withdrawing the gown from him. And Bar Council did the right thing by suspending him. And I will not take his name, तुम लोग मालूम कर लो. मुझे कुछ शर्म आती है ऐसे नालायक एडवोकेट के नाम लेने के लिए, to be frank with you. There are advocates like this who brought the administration of justice into disrepute. All lawyers are not paragon of virtue. Don't get carried away. This man talks well. He's having a senior gown. Many of them are evils. Many of them. Sweet talking, honey dripping sweetness. They cut your throat. Their intentions are not noble, many of them. But there are many of them are very upright and very good. You should not identify with your client, make wrong statement. There are many lawyers who are citing judgment which are overruled. There are lawyers who are citing legislation which are repealed by the parliament. It happened in my case, I will not take his name. It doesn't look nice. I feel very bad, you know. So these are the lawyers, commercial type of lawyers. Their intention is only to earn money. Very unfortunate. Such people are thriving in the profession. Very unfortunate. And Chief Justice Venkatachalaya made a remark in some of the lectures. You can read it here. He said, I am at pain to say that several of my colleagues are attending parties with senior lawyers and boozing, and they are corrupt, he said. That is the state of affair of Indian judiciary. This is the state. Very unfortunate, you know. Venkatachalaya's statement is on record. You can see that here. Chief Justice of India, now whose daughter is now presiding in the Supreme Court now. Very unfortunate. The state of judiciary in India is not very sound as we think that here. There are many black sheep in the profession. And people like me, and if you take up this matter, they don't like it. I at times lose my cool in the court of law. What's happening? And they may not appreciate it. But I am also a person who speaks. I do not mind calling a spade a spade. We take our time for the students and teach. I am teaching honorably to you all. I don't charge fees from the college. Because I feel whatever I should give back to the profession, something which I gave it. जरूरी नहीं कि हर चीज में पैसा बनाना है आपको. But many of them made money, commercialization as a practice. Very unfortunate. But I want you all to become totally noble. Don't bother about anybody. Do the law in a noble manner. Read the law as it is and take up the matter. Even poor people are coming free of charge. Karo, noble karo. Money will follow you. Don't run after money. Money will chase you. The moment you acquire name and fame, people will respect you. And be bold. Don't cow down. Don't say that here. Either ki udhar ke baad. Go strictly by law. Go by the noble virtues and practice. And read everything. Be well read. बहुत सब law पढ़िए. Don't say that I will only specialize in one ABC Act. सब पढ़ के रखिए. CPC, CRPC, Constitution, tribunals appear in all types of matters. If you want to become versatile, then you come to know what is reality. Okay. आज के लिए बस मंडे मिलेंगे. और कुछ पूछना है भी किसी को? Anybody, any has any question? Kumar will wind up now.
Yes, sir, we can.
जी? Anybody has any question last?
I don't think so.
Okay. Hello, everybody have a nice time.
Thank you, sir. Good night, sir.
Okay, good night. Tomorrow I will meet.